So over my 23-year legal career, I've probably drafted hundreds, if not thousands, of operating agreements. And when you draft that many, there are certain patterns you start to see, some of the biggest mistakes that people tend to make when drafting operating agreements. So in this video, we're going to talk about the top 5 dumbest mistakes I see in operating agreements. So the first biggest mistake is having a member-managed operating agreement. Now, if you guys remember, when you have an LLC, you're typically going to have first a member up here, and then you're also going to have a manager. And a lot of people use the same member as a manager, but the concern that we have here is that the manager is where all of the liability is. So from an asset protection standpoint, if anything were to go wrong with this entity in this example actually owns a piece of property, but the manager is the one making all the decisions. The manager is where all the liability is. So if the manager gets sued, we don't want it to have any ownership at anything, let alone the LLC. And so generally speaking, you want to have a different manager over here, and that's typically done in what we call a management LLC. That way, if there's a lawsuit, the lawsuit's against the management LLC and not the individual. And this is one of the biggest mistakes we see. You never, ever, ever want to have a member also be the manager of an LLC. The second reason we don't want to have a member manage is because of privacy. Generally speaking, when you set up an LLC, when you file the documents with the Secretary of State, most states, I would say all but 3, require that you put down the manager of the entity. And so if you've got your individual name as the manager, well, that's going to be all over the public records. Everybody's going to know that you are related to or actually own the LLC. And so by having a management company, we actually put that information in the filing documents with the Secretary of State. And that way we take away our personal name and take it off of the public records. The only information that's really on that public record is going to be whoever the manager is, which will be an LLC, and also the registered agent, which of course you're going to hire a third-party professional management company. And the third reason we don't want to have a member manage is in a situation where you have multiple members. If you have 3, 4, 5, 7 members that are the members of the LLC, you don't want to have 6, 7 members also be the managers. You want to select 1 or 2 or maybe 3 of those individuals and have those people be the manager. And so again, setting up a management company that has 1, 2, or 3 of the members be the managers of that management company helps with the decision making, so we don't have too many chefs in the kitchen. So the second mistake I see is not having specific asset protection language drafted into the operating agreement. I specifically see this issue when it's a single member LLC or sometimes a husband and wife. But you want to make sure you have language in the operating agreement that specifically addresses the situations where there's a third-party creditor that's gotten a judgment against you and has the possibility of having a charging order and coming in to take over the property. You want to make sure there's language in there that clearly states that the third-party creditor who has a judgment against you, the member, isn't going to have any rights or decision-making ability in the LLC. They don't have the right to make any decisions. They don't have any actual ownership. They're going to be limited to distributions if that's what the court determines. So it's very important to have a asset protection language in your operating agreement. Mistake number 3 is having no voting language for multiple managers. So often an operating agreement will have multiple managers, maybe 2, maybe 3, which is fine, but then there's no specific language in the operating agreement that dictates what actually constitutes a decision. Is it a majority vote of the managers? Is it a unanimous vote of the managers? Is it a particular manager that governs? There's no language in the operating agreement addressing that issue. And when that happens, typically we have to default to whatever the state LLC statutes enumerate. So we're going to go to your particular state, or actually the state where the LLC was set up, and we're going to look at the language there. And that's not something you want to have. So make sure you have language in your operating agreement that specifically states that in order for a decision to be valid, it needs to have either a unanimous or a majority or a supermajority vote of the managers. Mistake number 4 is overcomplicating your operating agreement. This is especially true when you have just a single member LLC. I can't tell you how many times I see a 40, 50, 60-page operating agreement when it's just you as the member. When it's a single member LLC, there's no reason to have such an overly complicated operating agreement. I think, in fact, our single member operating agreement is about 8 or 9 pages because a lot of the language you see in those large operating agreements just aren't relevant to single members. There's not going to be any language about how you vote and calling meetings, buy-sell agreements, or any language that involves more than one person. So if you have a single member LLC, keep the operating simple. Don't overcomplicate it by having a 40, 50-page operating agreement. And number 5 is having no buy-sell agreement in your operating agreement when you have another member in the LLC. So a buy-sell agreement basically outlines what happens if one of the members passes away, dies, has a serious injury, is incapacitated. What is a procedure for the surviving member? So most of the time, there's going to be a right of first refusal. If one of the partners dies, the other partner is going to have the right to purchase that person's shares, because otherwise it's going to go to who knows who their heirs are. Maybe you just get stuck doing business with that person's brother or spouse or kids, whatever. And so you want to have provisions in there that address the scenarios where if you get super sick or you're incapacitated or you die, that there's some language that addresses that particular situation. And before you guys go, I'll do a bonus mistake that I always see, and that is not having an operating agreement to begin with. Even though if it's a single member, you may think it's not necessary, at the very least, again, you want to have that asset protection language in there in case you get sued and there's a charging order or somebody's trying to take away the powers of that LLC away from you. You've got language in there that'll protect you. And so always have an operating agreement, even if it's just you. Remember, if you don't have one, the operating agreement will essentially default to whatever the LLC statute is in the state where you set up the LLC.